of your request to alter the
You have one email from 2015, which does seem to blur a little bit. I'll give you that. It's an instance where you're going through the U.S. Attorney's Office to short circuit the BOP process, and you seem to get something out of that. But that's one time 6 years ago. We're talking about 2021, and you have more than this email. You have the face of the regulations, which say that the administrative remedy program is available for complaints about the SAMs.
Well, Your Honor, I would point, so once Mr. Savage, after 8 years of requesting modifications to his SAMs and having his SAMs reissued without modification, Mr. Sams did engage again in the BOP grievance process in 2021. He filed a grievance, and in that grievance, it went to the warden of ADX. The warden, in his response to Mr. Savage, makes it clear. He says, quote, "Any such modification must be approved by the U.S. Attorney's Office for the Eastern District of Pennsylvania and the Federal Bureau of Investigation," end quote. Mr. True, the warden, goes on to say, quote, "Forwarded to and reviewed by the USAO/EDPA and the FBI," end quote, and only, quote, "These agencies may take action as necessary to grant the relief requested," end quote. He finishes his letter by saying, quote, "This response to your request for administrative remedy is for informational purposes only," end quote. Your Honor, I would submit that Mr. Savage attempted to use the BOP process. The warden at ADX Florence told Mr. Savage, "We have no power to grant your request. The only power we have is to forward your request to the respondents in this case, who will ultimately make a decision on the merits as to your request." Mr. Savage, in that case, Mr. Savage would basically the BOP would be transferring the request for relief back to the respondents who had already denied his request by reissuing his SAMs without modification. So that is not an available avenue of relief as contemplated by Ross v. Blake.
Mr. Hicks, we know that there are instances in which the warden of the facility has been able to, not necessarily this particular warden, but in cases in which the warden has been able to accommodate requests within the constraints imposed by the SAMs. That is, minor adjustments in the way things are done in order to provide some relief for the prisoner. Since sometimes the warden can do that, depending on the request. I think we know that the BOP is not entirely irrelevant in this process. It's not, in other words, simply a transmission belt to the Department of Justice. We also know from the Booth case, that even though in that particular case, there was no material prospect of relief, the court said, because the request was for monetary relief and that was not available, the court said that some relief still met the some relief standard, some relief being available. And I can only imagine that is because when some petitions could be handled by BOP, it only makes sense to filter them all through the warden and then on to justice, and the warden can't take the required action. So given Booth, I don't understand how you can say that here there was no prospect of relief.
Well, Your Honor, I believe that, again, I think that the differences in facts here, two things. Number one, the request that Mr. Savage was making in this case was the addition to additional contacts to his SAMs. It was not to the conditions of his confinement.
It was not what?
Not to the conditions of his confinement. There was no request that Mr. Savage change the number of phone calls, the number of emails or mail, anything else about his conditions of confinement. Rather, he was asking to add additional people to the SAMs. The regulations in this case are clear that the only people who have the power to add additional contacts to Mr. Savage's SAMs are the DOJ, respondents to the DOJ. So in these particular case, also given the fact that the DOJ told Mr. Savage that that was his own, that they were willing to grant him the relief in that avenue, and that
Well, look, the only way you can get relief from this court is from the judges. Right? Well, you have to file first with the clerk. And the clerk can look at your papers and say they are not appropriate for filing. It can be rejected. And that serves to make the system work reasonably more efficiently than it otherwise would. Seems to me that something like that is going out here. By requiring exhaustion of the ARP, the relief, such relief as can be given at the first level is given, and the rest are passed on to justice.
Well, I would set forth, Your Honor, that Mr. Savage has actually exhausted his administrative remedies, as was set forth to him by the defendants, the DOJ, that they have reissued his SAMs without modification, and that by doing that, his administrative remedies are exhausted.
How can that constitute exhaustion? The fact that you're saying that because he's asked before and has always been denied, that for not asking is sufficient.
Well, Your Honor, I would say that the DOJ had every opportunity to clarify that the only methodology for which Mr. Savage could seek redress was through the BOP grievance process. It never did so. Instead, it granted his previous request to add contacts by direct contact and told him that any denial going henceforth was a denial of his request.
Thank you. We'll give you some rebuttal.
Good morning, Your Honors. Janie Lilly for the federal government. I'd like to begin by responding to the argument that the Bureau of Prisons has no authority. As Judge Ginsburg pointed out, the Bureau does have authority to make certain modifications, and it importantly has input about on the ground information about both the inmate, perhaps the requested contacts. In the case of an educational institution, might have some information about how that institution has performed under similar restrictions in the past. And so in any event, the Bureau's administrative scheme remained available to Mr. Savage and continues to be available. It's clear in the regulation. That is how we should seek modification of the special administrative measures, and he acknowledged that by filing a request in 2021.
Ms. Lilly, if there was a final decision on the merits here, would that be an exception to the exhaustion requirement in the PLRA?
If there had been a final decision on the merits of his
I take that to be one of the arguments, that there was a final decision. And so would that be an exception to the exhaustion requirement?
Your Honor, if there had been a final decision on the merits in certain circumstances, that could satisfy exhaustion, but there wasn't one here. As Judge Katsas pointed out, there is a single email that it's unclear, and that illustrates precisely why it was vital for Mr. Savage to go through the Bureau's prescribed process. It was clear on the face of the regulation what he was required to do. It remains available to him here, and that's the way he can receive a final decision on the merits of his requests.
It seems very clear on the face of the regs, but there are two odd features in the documents. One is that 2015 email, which I mentioned, where he wants some relief. He goes through EDPA to end run BOP, and the response he gets back is not, you have to start with BOP. It's that EDPA takes it up to main justice, and the decision on the yearly reauthorization counts as a merits denial of his request. Now, I don't know, maybe the AUSA doesn't have authority to override the whole SAM process, but that tends to support his view of how this can work.
Well, Your Honor, the Supreme Court has said in Ross that where there's any ambiguity about the availability of a process or how it works, that the prisoner or the inmate is required to pursue all available remedies. And that's what the district court concluded in this case, that where it's unclear what you should do. Of course, we argue that it's not. The regulation is clear on its face, and we know that because he used the same process multiple times, including in the context of seeking additional social context. But where there's any lack of clarity, the onus is on the inmate, and that Congress was clear that the inmate should exhaust all available remedies. He hasn't, there's no basis for concluding that the normal process was unavailable to him. He knew that, and even subsequent to the email he points to, availed himself of the process multiple times in this. Thank you, Your Honor.
Thank you.
Thank you.
Rebuttal, if you have anything.
Just a couple of points. First, in terms of the input that the BOP may have in any process, the regulations on the SAMs are clear that what the DOJ would be looking at to determine whether to add additional members to his SAMs is whether the people he is requesting would be a danger, either a danger of death or serious bodily. There's no way for the BOP to be able to make that assessment. If he were to go through the BOP process.
You don't think it would, one relevant consideration would be the behavior of the prisoner and the facts on the ground at the prison?
Well, Your Honor, the DOJ already knows the behavior of the prisoner. It is incumbent in them in reissuing the SAMs to make a determination whether he continues to be a serious risk to death or serious bodily injury. It makes that assessment. It knows about him.
And the same issues would come up the same issues that would come up on the yearly renewal would come up on a request for modification.
Well, Your Honor, that's true, but Mr. Savage went through the process of the yearly renewal by directly contacting Mr. Troyer and then through him, Main Justice, and that process was successful. And at no point did they ever tell him that it could not be successful. As a matter of fact, they told him the opposite.
Let's assume that that gave him a reasonable ground for thinking that he could bypass BOP again and go directly to justice. It can't be permissible to rely on an informal resolution in a prior matter and to see that the government is somehow bound by that. The government moves through official proceedings. And there are any number of cases in which, in this court and elsewhere, in which people have relied to their detriment on an informal assurance from some government agency.
Well, Your Honor, I would say that in this case that the formal proceeding in this case is looking at the renewal of the SAMs itself. So every year the DOJ goes through the process of renewing the SAMs. It's supposedly the basis of the substance of this lawsuit is whether the DOJ actually does the work of looking to Mr. Savage's behavior and deciding whether he is still a danger. And we couldn't even get to that point because it was dismissed for lack of exhaustion. But the point is that every year they go through that process. Every year Mr. Savage has filed a formal letter asking them to please reconsider and to add additional family members, his grandchildren, the mothers of his children to the SAMs, and it has been repeatedly denied by the reissuance of the SAMs without modification. We believe there has been a formal process, and that is a final decision on the merits.
Sure, why the repeated denials at the level of the Department of Justice is a reason for being able to not proceed through BOP, and it sounds like it's a reason to not bother going to justice again.
Well, Your Honor, I don't believe that's the case. Again, I think that the facts here are particular in that the only ones, if you look at the regulation, the only ones who can add members to Mr. Savage's SAMs are the DOJ. And I think that if Mr. Savage was asking for additional phone calls or other conditions of confinement where the BOP would have important input into whether the decision is made, I think that would be appropriate, but under these facts, it would not be.
Did you have an answer to the Booth question before?
I'm sorry?
Did you have an answer before? I don't recall to the, what do you do with the Booth case? Prisoner was seeking monetary relief.
Oh, yes. Well, Your Honor, in Booth, there was the grievance was not just the monetary remedies, there were also other things the BOP could do in that case. And the argument here is that there's no power that the BOP has in which to modify the SAMs in the way that Mr. Savage has actually. In Booth, the BOP had the power to, look at other measures that might be able to fulfill the prisoner's grievance other than monetary remedies. I don't believe that's the case here.
Okay, take a look at that again.
And one last point, Your Honors. So look at how the judge, counsel stated that the judge construed the facts here as to be against my client because there is some ambiguity in the letter from Mr. Troyer and that Mr. Savage had a requirement to exhaust all avenues of administrative remedies. We would say that that actually bodes for reversing here rather than upholding, in that this is a motion for summary judgment. All facts should have been construed in the light most favorable to Mr. Savage. The judge did not do that. The judge looked at the ambiguity and construed it in favor of the government, which violates the standard for summary judgment. That is also a reason to reverse.
Thank you.
Thank you, Your Honor.
Case is submitted.
Case number 22-1332 et al. NCRNC LLC doing business as Northeast Center for Rehabilitation and Brain Injury petitioner versus National Labor Relations Board. Ms. Lanuette for the petitioner, Mr. Weitz for the respondent.
Whenever you're ready.
Good morning, Your Honors. This case arises out of a union organizing campaign at a long-term care center specific for individuals with traumatic brain injury. And that's important because the board erred in finding that NCRNC's instruction to its supervisors was surveillance and that they committed surveillance, especially in the healthcare context. Supreme Court has said healthcare is in patient areas, patient locations is entitled to have stricter rules than maybe would exist in other places and areas. The board found surveillance, uncharged conduct, by the way, in two areas: the manager on duty program that the Northeast Center ran, and in handing out of flyers by supervisors to employees.
Let's just stipulate that Section 8C protects the flyers. I'm with you on that. But the manager on duty program,
Yes.
why is that finding not supported by substantial evidence? You have testimony that they put in place this program, managers are showing up in weird hours at weird places, and that tends to be that one can easily imagine that's intimidating to employees.
It might be intimidating if they were showing up in break rooms and parking lots and places where union organizing activity generally occurs. That was never the instruction. Nobody testified to that. The instruction was to come in and to monitor workplaces, patient care areas, the units for the unit managers, and department heads to monitor employees. And her specific testimony was, we were told to look to make sure employees were doing their jobs.
Was it just, I thought it was not just unit managers. It went all the way up to Mr. Weir.
Mr. Weir had started his program in July. There is evidence in the record. The general counsel submitted emails from Mr. Weir to the other people in the company saying, I'm already going to every unit every day. I've been on every shift. I've met with employees. And that was A405. That email is sent July 9th, and A403. Him saying, we're already doing this. We've started it. They brought in the consultants at that time because the comment heard in the hallway was, maybe we should get a union in here. That's all the comment was. There wasn't any more than that. A manager overheard it. And the consultants in July, well before they knew there was a union organizing campaign, suggested they start bringing in supervisors and managers more often. Look, these people were supposed to be there anyway.
Was there any rationale given?
The employees on the night and evening shift did not have enough contact with their supervisors. The facility was short-staffed. Everybody said that. That was actually one of the precipitating events for union organizing campaign. And that supervisors needed to be doing more to help their employees on the night shift and the evening shift.
There would certainly be substantial evidence to support a conclusion that that was the reason for the program and it was perfectly appropriate and perfectly fine, right? But there's other evidence.
I don't think there
Right?
is.
You need to negate the worst evidence.
And I don't think there is other evidence. The instruction that Tara Golan testified to was to come into our units, which is where they're supposed to supervise anyway, and look to see if employees were doing something suspicious, gathering in groups and not working. And when the ALJ asked her to clarify what she meant, she said, well, basically we were supposed to look to see if they were working. That's not surveillance. That's doing your job
But
as a
here in
supervisor.
Northeast, I mean, doesn't really challenge the credibility determinations of the ALJ, which were affirmed by the board. And those credibility determinations were overwhelmingly in favor, were against Northeast. And it's obviously a hard standard to rebut credibility determinations, but without any challenge to the credibility determinations, how do we find that there was not substantial evidence here for what the board did?
But it's not the only evidence is her testimony that this is Tara Golden's testimony. And her testimony was they were to look for employees not doing work on work time. There is no evidence in the record that they went, say, to the break rooms. Sprainbrook, which the board relies heavily on, the manager comes in and stands outside of a door where they know there's a union meeting and watches people going in and out. That never happened here. There's evidence in the record that even the nurses station, they were not told to go to the nurses station. It just can't be that an employer can't say to its employees, especially in a healthcare setting where there are patients, you can't increase the number of supervisors walking around at some point in time because that's better for the facility. I mean, it's a legal determination whether that's coercive or not. That's not a factual determination. It's a legal one. The legal standard is whether it's coercive, whether it's interfering with union activity.
Why isn't it a factual question whether the specific program actions of the supervisors and such would tend to coerce, whatever the verbs in 8A1, coerce,
restrain, or interfere.
Or interfere.
Yeah. So that's a legal conclusion. Can you coerce, restrain, or interfere somebody if the only place that the supervisors are active is in patient care areas during work time? They shouldn't be union organizing there anyway, right? This is patient care areas during work time, not the nurses station even, not the break rooms, not the parking lots. This is work area, work time. It can't be coercive there. It can't be interfering because they're not supposed to be doing it there anyway. They're supposed to be working, caring for these brain injured patients.
Suppose, I don't know, this probably isn't the facts, but suppose Mr. Weir starts showing up, or, the CEO of the parent company shows up, making the rounds, poking around. You don't think that might tend to interfere, right? Send a message, we're watching you, we're upset about this, you better be careful.
So Mr. Weir is the administrator. He actually was legally required to do rounds every shift. But you're talking about Mr. Camerota, yep, from the. Suppose we bring in outside people and we walk them around and we start following people. I think that's coercive, sure. But that didn't. There's
managers who are outside the chain of command couple steps up the chain of
But
command?
they weren't. The unit managers were on their units. The employee who was a union employee testified that her unit manager had been on her unit on all shifts prior to the union organizing. That was normal. The only unit manager that said she'd never been there before was Tara Golden. And the judge found credibility just that she did not know what her job was. That was his credibility finding for her. The other people were department heads, but department heads had employees throughout the facility. CSS workers worked on every shift, every floor. The CSS department head walking around checking on his employees to see if they're working is just supervision. It's nothing more, especially if it's in patient areas. Same thing. Now, there is a question about Department of Dietary and Housekeeping. Those people were not Northeast employees. Those departments were outsourced, and there was testimony to that, and the ALJ found that they were outsourced departments. So the Northeast can't be responsible for what the outsourced departments did with regard to their employees. There wasn't any communication between them and for instance, Northeast that was in the.
Counsel, I want to go back to Mr. Weir for a moment. You said he began his practice in July.
Yes.
But it's my understanding that the first hint of union activity was in late June.
There was a comment made in July at the nurses' station. Maybe we should get a union in here. That was the only comment that was made. The only union activity occurred much later.
And remind me in the record, who recounted that?
It was a supervisor walking by who overheard the comment, reported it to Mr. Weir.
And that was in late June.
That was July 9th.
I'm sorry, July what?
July 9th.
July 9th. And that's when did Weir first begin?
Weir began in February.
No,
And-
was walking through the
Oh,
units.
in the email on July 9th, he said, in response to a question of, well, why is this the first we're hearing about it? He said, I had already met with all employees on every shift. I've met with them several times. I've been walking through the building on several shifts. He had started well before that.
Started working there, you mean, not started?
No, he had started his shift, walking around, meeting with employees. On the day that they find out that there's this comment about maybe we should talk to a union, he sends an email saying, I've already met with, I've had departmental meetings with staff present. I've been to every unit on every shift numerous times. He says that.
But I thought
The
you said
same.
earlier that his conduct began well before there was any union
It did.
activity, but not before the first mention of
No, it did.
the union.
He sends that email saying, I've already done all of that on the same day they find out about the possible union. And the only comment is maybe we should get a union. Not look at a card, not, do you want to come to a meeting? It was just maybe we should get a union in here
That-
in response to a question about being short-staffed.
Certainly,
staff.
that's certainly not helpful, I'm sorry to say.
Well, I think though, if he's saying on July 9th, I've already done this, and that's the first word they have of a union, the manager on duty program is already in place. It's in place because he says, I've already done it. I've been to every shift numerous times.
I'm going to take a look at that.
It's in the record A403. It was a general counsel exhibit 8.
Ask about Mr. Endy while,
Yes.
while Judge Ginsburg is
Absolutely.
running that down. One consideration that seems to cut against supervisor status is that the assignment function that he performed when he was the ranking supervisor is a pretty small percentage of his work time. So let me just sketch it out for you and then I'll let you respond. He takes 15 minutes to do this at the start of his shift. You know, I assume let's say he works an 8-hour shift. He's the ranking supervisor 2 days a week. It's 30 minutes out of 40 hours, 1/80. And there seem to be cases, this wasn't a big part of the board's rationale, but there seem to be cases suggesting that if you're acting as a supervisor part-time, you know, you got to be like north of 10%, and he's not.
I think he is.
I just gave you 30 minutes out of 40 hours. Why is that the wrong way
Sure.
of thinking about it?
So the testimony was that on a good day, it took 15 minutes, but typically it took 30 to 45 because of having.
Typically
30 to 45.
I thought it was typically 10 to 15 and occasionally 30.
They said, I believe
I'll
Josie
check.
Cruz said it was typically more because of the callouts. And when I asked Mr. Endy about that, he agreed that it was more difficult because they regularly had employees call out. And so they would then have to redo the assignment they had planned.
You mean
But even
call
if-
out, like not show up for work?
Yeah, not show up for work. This is a low wage job. It's, you know, the supervisors get additional training, but the employees don't. And so they tend to call out when they don't want to be there. That was one of the problems. Both supervisors also testified that during the shift, they would occasionally, or actually Josie Cruz said on a regular basis,
So
have to
let's
make.
just, before we get to during the shift. So 45 minutes, twice a week, 1.5 hours out of 40. You're still.
But how different is that from Oakwood Healthcare, where the nurses are assigned at the beginning of the shift, the CNAs are assigned at the beginning of the shift? That's not taking any more
I
time.
thought the nurse in question was a full-time supervisor. Am I wrong about that?
I don't think they full-time
I'll
assigned
go back.
work, though. And he is a full-time supervisor. I don't think it's fair to say he's not.
Well, okay, so that's leading to the other point I wanted to ask you, which is he sort of is and he sort of isn't. I mean, he's only doing this assignment when, is it Ms. Cruz is not there? And
So that was not actually what the record showed. We put in all of the assignment sheets, and more often than not, he made the assignment even if she was there.
what is he doing? So on the days, or on the nights when he is doing the assigning, and it takes 15 minutes or 45 minutes, whatever it is, what is he doing after that? Is he just is he just doing CSS line function, or is he actively supervising for his whole shift?
He is actively supervising for his whole shift. The supervisor was responsible to walk around and check on employees to see if they weren't doing their work, to see if they had any problems. He would have to deal with a problem if a patient and a CSS were not getting along. He would switch who was taking which job function. And this is all in his testimony. He would give them their breaks. So he would say, okay, it's your break time now. You go on break. I'll cover for you while you're on break. It's your lunch hour. Go half hour. Go take your lunch half hour. I'll cover this while you're doing that. He responded to codes. Code rainbows, a violet patient, he would be there responding to those as a supervisor or whoever was the supervisor. If there was a moon, which was a patient got out of the facility, the CSS supervisor would typically be the person who would go look for them because the nursing supervisor could not leave the perimeter of the
How are
facility.
those functions supervisory? I mean, those sound like part of the duties of his employment.
Well, they're supervisory in that he's helping the night nurse supervisor with the employees who are doing things. Breaking employees, deciding when they go on break, deciding when they are, who's working with whom, switching people up. That's all supervisory.
Even if some of that requires, you know, the independent judgment of a supervisor, why isn't it routine and clerical?
I don't think it's routine and clerical because he's comparing, the rule is he has to compare data, right? So deciding that this person is going to be better off on the phones because they have phone experience and computer experience. He said there were 3 to 4 who could do that. Other people couldn't. Deciding that this employee is not working out with this patient right now, and I could pull a different employee and put them in here. It's comparing data, it's making decisions, judgment. I would say that's no different than saying, well, lawyers all have the same training, but the guy who's in jail today representing incarcerated inmates is having a far different day than I am. And the supervisor who assigns it can affect the way their day.
Well, I mean, it may well have an effect, but that doesn't mean it's not routine and clerical. I mean, there can be, I mean, the statute sort of envisions that there are circumstances when which someone exercises independent judgment,
Right.
but the matters are still routine and clerical. So it still has to be something, something other than routine and clerical.
But one of the things that the standard says is that it's the ability to affect the employee's work conditions for the night. And that's really the question here. Should somebody who can tell you whether or not you're working in a locked unit with violent patients or having to just walk around, check on people sleeping, be able to coerce you into signing a union? That was the bottom line for this, right? He's a supervisor. He's passing out cards telling employees they have to sign them. Is it okay in this circumstance for him to do that? And I think the law says it's not, because he can affect these employees night to night. He can issue discipline to them and did. He can tell them to go to, this locked unit with violent patients and work there for your night, or walk around and not deal with much. It just seems to me that that person shouldn't be able to tell the employees he gets to assign and he gets to discipline, sign this union card. There's an implicit threat there, or I'll give you a crappy shift, right? That's a supervisor. That's why we don't allow them to do that. See, my time is up.
Okay, thank you.
Thank
We'll
you.
give you some rebuttal. We'll hear from the board.
Good morning.
Mr. Whites.
Yes, good morning. May it please the court. Eric Whites on behalf of the National Labor Relations Board. I'd like to begin just by clarifying one point on the unlawful surveillance finding to Your Honor's question. The board did not find that the passing out of flyers was a separate unfair labor practice in any way. In fact, the employer had been passing out those flyers throughout this campaign. For example, in the routine course of the day when supervisors were seeing employees. The board did not find that that was unlawful. What the board found was, as part of this out of the ordinary change in practice, when all of these senior managers began coming into the facility to observe employees and to interact with them to try to suss out their union sympathies, part of that was passing out these flyers and observing how they reacted. But the board's ultimate finding was an unlawful surveillance finding based on the unusual and coercive presence of individuals.
Based in part on the managers showing up, managers outside the chain of command showing up in odd places at odd hours. I'll give you that. But part of it was the passing out the leaflets.
That's correct, Your Honor, because that shows
23 on page 12 of the appendix. The board is talking about surveillance, and they say that this one-on-one interaction when the supervisory employees are lawfully passing out literature is part of the surveillance, because they're not closing their eyes when they lawfully speak to employees.
That's absolutely.
You want to defend that?
Well, that's absolutely correct, Your Honor. But I guess my point is the employer was doing that in a non-out of the ordinary way, and the board did not take any issue with that or say that this type of one-on-one persuasion is unlawful. They're specifically citing this as one of the practices that the managers were doing that highlights how out of the ordinary and coercive this was, because it was not about telling employees to do a good job at work. As Ms. Golden credibly testified, the entire purpose of this change in policy was about the union campaign to identify and potentially observe union activity and try to suss out individual employees' opinions about the union. And so that's why the board found it significant. But as the board clarified in response to dissenting board member,
done in private places or coercively. Well, the one-on-one persuasion is okay. And then whatever and assume no interrogation. But if the representative of the employer observes the body language, if the employee volunteers a comment and such, what's your position on, can the manager report that back to the senior leaders?
I think, I mean, I don't want to take a position for the board, but I'd note that here the board, the employer was doing that in the normal course or in a not coercive way, and the board did not find that was an unfair labor practice. What the board found, just to take a step back and sort of highlight the facts of what was going on here, is when you have senior employees, division heads, the head of the facility coming into locations where they're usually not going, coming in at unusual times. For example, they were coming on the night shift, so you'd have an unfamiliar senior manager coming in at midnight, interacting with employees in part by handing out these flyers and then watching the employee. The board found that that entire course of conduct constituted unlawful surveillance and was coercive. The board did not single out the flyer aspect of that. And that's why, as we argue in the brief, I think the Section 8C argument is sort of an opposite here. I'd also note that, as we note in the brief, the employer did not raise this to the board. And in fact, we submit it's jurisdictionally barred by Section 10E because the employer did not even argue this during the board proceeding.
Put aside preservation just to tie this down. The discussion of 8C in this footnote, it's a little bit murky, but they don't say that the leafleting was done by managers who were oddly out of place and there in weird hours, in which case, maybe the leafleting collapses into the concern about unusual practices. What they said was the employers may not place employees in a position where they must make an observable choice between support for unionization and opposition. And that's in the context of this concern about managers reporting back on how employees are reacting. So this seems to be saying there's a problem with one-on-one leafleting because the employer can observe the reaction of the employees.
Well, I think what the board was doing in that footnote was noting in response to Member Ring that the finding here is consistent with prior board precedent, including what you just cited, Your Honor. But I'd note that impliedly, this entire discussion is in the context of the out of the ordinary unlawful surveillance because the board did not make a separate finding. If you look at the board's conclusions of law or its remedial order for the court, they did not prohibit the employer from leafleting. They prohibited the employer from engaging in unlawful surveillance.
True. The count is unlawful surveillance and the ordering language doesn't break apart the leafleting aspect from the manager on duty program.
So I would submit that, if a future case it was alleged, then the board found that non-out of the ordinary leafleting was at issue, that would be an interesting question or an issue to litigate in that case. But in this particular case before the court, I think all that the board ultimately found was that this entire course of conduct was unlawful.
Suppose, just for the sake of argument, suppose there's preservation on the 8C issue, and suppose we conclude that the board's finding is fine as applied to manager on duty, not fine as applied to leafleting. Can we unpack those two? Is there sufficient evidence that the manager on duty aspect of it would independently support the finding and that's what the board would want?
I think so, Your Honor. I think that was the thrust of the board's finding. In fact, I think I would submit the strongest evidence here is not the leafleting, but the credited testimony of Ms. Golden, who was a manager present at all of these behind the scenes meetings. And contrary to what my opponent has argued, Mrs. Golden's testimony was very clear that the entire purpose of this change in policy was to target the union campaign and to see if employees were discussing, having group conversations, see if they became quiet when managers approached, and to report back on individual employees and what their union sympathies might be. So even without the actual flyer aspect, I think that's merely reinforcing the fact that this was not a legitimate business decision. It was targeting the union in an out of the ordinary way that would be at least have a reasonable tendency to coerce employees, which is the standard for an 8A1 violation. I'd also note, just responding to something that came up earlier, the question of this July email with Mr. Weir. If the court actually looks at that email, the entire email is about how they're worried that the union campaign had started at the facility, and he was reporting to the employer's corporate parent. And as part of that email, he said he had already tried to get ahead of it by going around the facility to try to take the temperature of the employees. So there's no evidence at all that there was this quote unquote manager on duty program that existed prior to the union. And as Ms. Golden's testimony makes clear, and at the timing, as employees testified when they noticed this change, it was all in response to the union campaign, and the employers never presented a legitimate basis for what it was doing, having senior managers come in at midnight in unfamiliar units where they could not assist the employees. In fact, there was testimony that their presence was very disruptive to patient care because they were just getting in the way of these nurses doing their jobs. If I could turn any further questions about surveillance, I could.
Can we go?
Sorry. I'm not sure that the employer's purpose is really relevant, or is certainly insufficient, absent some finding on tendency to coerce.
Well, it's true that this is a Section 8A1 violation, so motive is not a requirement of the violation. It's ultimately just an objective question of, would this conduct have a reasonable tendency to coerce employees given the overall circumstances?
And that question, with respect to various practices, particularly in campaigns, electoral campaigns, has been the subject of reversal and reestablishment, reversal. And so with respect to certain practices, because, as I understand it, that's a matter of judgment within the province of the board.
That's correct, Your Honor. I think this is a fact-bound determination that's uniquely in the board's expertise in determining this. And I think this case is actually very similar to, for example, the Parsippany Hotel case, where this court affirmed the board, where you had a similar situation where during a union campaign, the employer increased the number of guards at the facility who went around or observed employees in the workplace, some of which was in work areas, just going about their daily duties. And the board in this court found that given the overall circumstances, that would be coercive to employees and would constitute a violation.
But my point is that had the board said that was not coercive, we would have also affirmed.
Well, it would be a substantial evidence standard of review, which I think this entire case is. So the board could make that's the standard of review.
Have substantial evidence that something was not coercive? I don't think.
I think so, because the standard is, could a reasonable fact finder reach a particular conclusion based on this evidence? So the board may have reason to
say something was substantial evidence that was not coercive. I mean, I guess the union would have standing to object to that, but I'm not sure what kind of presentation could possibly prevail.
I think it's substantial evidence that viewing these facts, there's a factual finding of how it would impact a reasonable employee. And that's something.
It's a matter of actual employees saying they were coerced or were not coerced, correct?
That's not the standard. You don't need to have actual coercion, although I would note in this particular case, you did have testimony of employees who found this very unusual and abnormal.
Mr. Reeds, do you think the board's finding on unlawful surveillance could be supported simply with Leonard's testimony, or do you need both? There are parts of the board's decision that seem to suggest that Leonard's, testimony was sufficient.
I think it probably would be sufficient. Obviously, here you have both, and as Your Honor noted earlier, credibility of Ms. Golden's not disputed, but I think Ms. Leonard's testimony alone established the fact that these unusual high-ranking officials were coming in at unusual hours, and employees found it strange in the context of this union campaign. I think Ms. Golden's testimony just really makes it beyond question, in my view at least, because she was present at the planning meetings where the employer discussed why it was doing all this and what it wanted the managers to do. But even if you didn't have that, which in a normal case, you would not have a manager being so candid.
There does seem some circularity with using Ms. Golden's testimony because of course the employer suggests that she was not really acting as a supervisor and not really, acting on behalf of the employer. And so crediting, her testimony about what was happening and why, I do think there's some circularity problems there.
Well, I mean, it was not really her testimony about, because she actually, as we can get into the discharge if you like, but she refused to do this. But her testimony, what was so persuasive, I think, is she was testifying about the group meetings where the employer and the union avoidance consultants met with the managers and also individual meetings with her and explained what the purpose of this policy was and what the employer wanted the managers to do, to go throughout the facility and to observe employees and specifically about the union. But again, I would just emphasize that the employer is never challenged for credibility as a witness, even if he may have conflicting interests in this case, obviously.
We talk about the ND supervisor issue. Seems to me a close question, but the board's rationale seems a little hard to defend. The board said that the assigning tasks did not involve independent judgment because there was no objectively wrong answer to the decisions, and relatedly, everyone on staff, the CSS employees, were capable of performing all the tasks. I would think those considerations tend to prove that there was independent judgment. If there's a clearly wrong answer, you're just doing math or something, that's not independent judgment.
I think the point that the
Independent
board...
judgment is, there's no obvious answer. We write difficult opinions and the majority might be right, the dissent might be right. The open-ended, debatable nature of the decision is exactly what proves that there's independent judgment.
I think that's absolutely right, Your Honor. And I think the board was making a separate point because it's also a principle under board law that if the outcome is obvious, for example, you have one employee who can do a particular skill, that is not independent judgment. I think the point the board was making here, specifically in contrasting this case with Oakwood Healthcare, for example, just as an illustrative example, that was a case where you had a charge nurse at a hospital and the decisions that the charge nurse was doing in matching patients to nurses based on skills and a plethora of factors could have life and death decisions. These are significant discretionary calls that the supervisor has to make. Obviously, supervisory authority doesn't need to rise to that level, but independent judgment is a question of degree, where the board makes a discretionary determination. Was this independent judgment sufficiently important? Did it require sufficient evaluation of data or supervisory consideration to rise to the level of to deny someone all of their rights under federal law? And what the board was saying here is that the decisions that Mr. Endy made when he was assigning employees were very routine and mundane because all of these employees have the same training. They're all capable of performing the handful of regular postings that they're de facto rotated between. And so there wasn't any supervisory meaningful choices that he had to make because he simply took into account preferences, whether employees had been in a particular assignment too often recently, he made an obvious choice, which I think goes to Your Honor's point, where if you had a female employee, he would make sure that they were assigned with a more senior coworker when they were assigned to the unit where you potentially had sexually violent patients.
Well, was that a policy shared by all the others, or was that this individual's determination of what would be inappropriate?
I don't know if there was testimony about what Ms. Cruz did or Mr. DeAbreu, but I would submit that that's a sort of self-evident, obvious determination. And I'd also note that he did not.
No, I think somebody could equally look at that and say, gee, I'm not supposed to discriminate on the basis of gender, so I'm going to treat everybody alike. I mean, it's like, you know, they joined up for the Army, they joined up for this job.
Well, I would note, Your Honor, that he didn't exclude any employees from this unit. He just made a sort of routine administrative call that I'm just going to make sure that that employee is paired with a more senior coworker when that situation arose. But again, I just.
But that may have been, all we know is that he did that. We don't know whether it was routine and everyone else did it, or it was his decision, his prudence that was led him to that.
That's true, Your Honor. I would make a overall point in response to that question, which is just to highlight to the court that this entire inquiry, the employer has the burden of proof. And for some of these factors, the board and the ALJ noted that really the determination was based on the fact that the evidence just wasn't conclusive, which is the employer did not satisfy its burden to show that he was exercising independent judgment. And I'd also note that it's certainly true that Mr. Endy exercised some discretion, but the framework under Section 211, as the Supreme Court has pointed out, recognizes that you'll have lead employees. I think Mr. Endy is a quintessential lead employee who perform minor supervisory duties. That's separate from the question of whether their duties rise to the level to satisfy the three factors under Section 211, including assignment with independent judgment. And
why is that? And the statute says assignment is a supervisory function. There's no dispute that he was engaged in assignment. And then the question of the independent judgment, the degree of difficulty, importance, open-endedness of those assignment decisions, they just are what they are. They don't turn on anything else he was or wasn't doing.
well, that's true, Your Honor, but I think it isn't necessarily a discretionary call of whether this particular, what the evidence shows, what was proven as to this particular assignment authority, whether that rises to the level of independent judgment, because certainly any kind of assignment where it's not written out for you in advance requires some discretion. But I think it's well established that if you're just doing something routine or administrative, as I think Mr. Endy was here, that's not statutory supervisory authority. It's not sufficient to deny someone all of their protection under federal law. And as this court has recognized, and as we cite in our brief, this court has held that that's uniquely within the board's expertise and that the court affords additional deference to that determination.
One theory that the board might have pressed but didn't is the one I was asking your friend about, which is these assignments were a very small fraction of Endy's overall shift. Is there some reason why the board did not stress that?
I know, Your Honor, there is a doctrine, I don't want to state what it is since it wasn't litigated, where a supervisor can be performing supervisory duties on such a ad hoc basis that it's not sufficient. I think perhaps the board here didn't go that route because this was admittedly a regular part of Mr. Endy's duties. He did this on a regular basis. And courts have held that as long as you have the authority and exercise it on some occasion, that can be sufficient. And so I think the board didn't need to get into Your Honor's point because they found on the threshold that what he was doing wasn't supervisory at all, regardless of how much time it took. I would make a factual.
So you're comfortable with us deciding the supervisor question just looking at what he was doing during those 15 minutes or 45 minutes or whatever it was?
I think, yes, you could have supervisory assignment authority, even if it wasn't like the charge nurses in Oakwood, where that was mainly their full job throughout the day. You could have a more limited duration and it could still constitute supervisory assignment. I would just make a factual clarifying point here, Your Honor, since there was some discussion about the time that it took. I think Ms. Cruz testified that on the long end, it would be 30 minutes.
Yeah, that was my
the board credited the idea was 15 minutes. I think Mr. Endy actually testified it was even less. And Ms. Cruz, when she noted it was 30 minutes because of the call outs, that was because she was essentially waiting for employees to arrive, and that could take a while. It wasn't because she was sitting down deliberating for 30 minutes. So are there any further questions about?
Mr. Weissio, what was the case you referred to when you used the phrase making life, I presume metaphorically, life and death decisions?
Well, that was Oakwood Healthcare. I think it was a literal termination there. The employer cites Oakwood as supporting its position here, but that case involved charge nurses at a hospital. And as patients came in, they had to assign patients to particular nurses based on that patient's issues, based on the nurse's skill, based on a myriad factors. And that's why the board found supervisory authority there, which is very different than.
And the CSS line people are more like orderlies, I assume.
Exactly. They're not medical professionals. They all receive the same very basic training, and they are essentially orderlies, and they patrol the building or observe people and have some sense of enforcing security. If there aren't any further questions about Mr. Endy or any of the other disputed unfair labor practices,
I think we are good. So thank you very much.
right, we'd ask for full enforcement. Thank you.
Rebuttal.
Let's start with those life or death decisions. There's certainly possibility of a life or death decision when you assign the wrong person to deal with a violent patient in the MBI unit. There's certainly the possibility of a life or death decision when you assign the wrong person to entertain one of the brain injured patients down below, and it gets them more agitated and upset than helping them. I understand these aren't nurses, but there is the same considerations of, can this person do this job? Can they be with this person? Can they handle them all night? It's not the case.
There is a difference in degree, right?
Well, there's a difference in skill set. I don't know if there's a difference in degree. You know, a nurse is a nurse. A nurse can perform all of their nursing functions. If we're talking about the only renal care nurse being assigned to the only renal care patient, there's no discretion there. I would argue there's more discretion here, where we're talking about employees having to match closely with the patients that they're caring for. There was no policy that excluded women from working alone at MBI. And in fact, the records which start on A622 will show Josie Cruz worked alone in MBI as a female employee. There were others. I think Anita Rogers worked alone in MBI as a female employee. There's no policy that they couldn't. Mr. Endy said he preferred not to, and he didn't find it to be the most productive. That's okay. That's his discretion and judgment. But it wasn't the case that nobody had that. I think it's important. A169, Josh Endy testified they had tried a strict rotation where employees simply were rotated, and it did not work. They went back to having the supervisors make those decisions. I think that only shows that there had to be discretion. I would also point out that while the judges declined to consider it, he did also issue discipline to employees, including doing third step write-ups all on his own, and that's in the record. In terms of the outside the chain of command, I think it's important. These were not the people from corporate that came in and started running around. These were people employed at the facility.
Now you're back to surveillance.
Yeah, the department heads were not outside the chain of command. Their employees were working when they were there on these units. Their employees work throughout the building. They just may not have been assigned to a particular unit. I see that I'm out of time.
Judge Ginsburg. No? Judge Rao.
Yeah.
Okay.
Thank you.
Thank you. The case is submitted.
This honorable court now stands adjourned until Monday, October 16th at 9:30 a.m.